What's up everyone, it's the Law School Lumberjack. Today we're going to be adding another installment to our Property Law 101 Fee is Not Simple series. And today we're going to be talking about the complex topic of life estates. So we're going to be going through what is a life estate, the general obligations of a recipient of a life estate, and some issues which can come up in law school exams with respect to life estates and the conditions that can be placed on life estates. So this is a companion video to the fee simple video I did recently. I've linked the video in the description. If you have any questions about fee simple interests and you think that this life estate video is helpful, feel free to check that out as well. So let's start off with the basics. So the first and basic topic is, what is a life estate? So a life estate, or a life tenancy, is granted by a party, who we call the transferor, and allows a person, who we call the life tenant, to benefit from the lands for the duration of his or her life. Essentially, once the life tenant dies, then their right to the interest in the land dissipates or is extinguished. So once the life estate ends, the property is then transferred to a remainder man, who is usually a third party, and that transfer is usually in fee simple. So I'll give you an example, because that's probably the easiest way to make it really clear what a life estate is. And so the wording of a life estate is usually that you give property to someone for life and then to a third party afterwards. So as I said in my previous video, I always use Abe, Bob, and Claire in my videos. So for those who didn't watch my last video, Abe and Claire are husband and wife, and Bob is Abe's brother. So let's say that Abe has property in his hometown of Toronto and grants a life estate to his wife Claire, but also wants to take care of his brother once Claire dies. So he basically says, and this is how you kind of create the life estate in the language that you'll see in the law school cases, I grant a life estate in my house in Toronto to my wife Claire and the remainder interest to Bob. Another way of putting it is I grant a life estate in my house in Toronto to my wife Claire. However, once she is deceased, this interest will transfer to Bob. In this example, Claire is the life tenant and Bob is the remainder man. Since both of their interests are unconditional, their interests in the property are vested. Now, I'm going to go through a little bit of a tangent here as to what is vested versus unvested interests. So this is often quite confusing to people listening in class. Essentially, if there are no conditions in the transfer language, then their interests are vested. However, if there are conditions attached to obtaining the rights, and those conditions have not been satisfied, then the interests are unvested. So let me use an example because I think this will make it a lot clearer. So let's forget what Abe said in the previous example. Let's say instead of what he said in the previous example, Abe says, I grant a life estate in my house to my wife Claire with the remainder to Bob if Bob survives Claire. In this case, because we know Claire will get the life estate regardless, Claire's interest is vested. However, because Bob's interest is contingent on him surviving Claire, his interest, or his fee simple interest, remains unvested until such time that Claire passes away. Once Claire passes away and Bob is still alive, then Bob will obtain the rights to the land in fee simple, and it's clear that he will, there's no conditions attached, he will then have a vested interest in the property. So now we're going to move on to some more in-depth topics, specifically about the obligations of a life tenant and some of the limitations that can be found with respect to a life estate. Presumptively, a life estate tenant has an obligation to keep the property in good condition, or at least as in good condition as it was at the time of the transfer, and additionally, they cannot encroach on the capital of the property. These two topics are extremely important in your property law course, and they sometimes can cause people to be a bit confused. So firstly, the life estate tenant, because there's a remainder interest, or there's a person down the line who will be obtaining the property, the life estate tenant has an obligation to maintain the property, and they have to avoid damaging the property. This is because they're not the fee simple owner of the land, and so they only have a specific bundle of rights, while the remainder man has the fee simple interest and has a much greater bundle of rights. Damage or disarray to a property is known as wastage or waste. So the life estate tenant has an obligation not to let the land waste. The life estate tenant, therefore, has an obligation to prevent waste, both by maintaining the property, as we would imagine, cutting the lawn, making sure that the roof isn't leaking, etc., and it has to do this to a reasonable standard. However, what we sometimes forget is the life estate tenant also has an obligation to take reasonable steps to ensure that the actual property, the security of the property, is protected. And what I mean by that is the life estate tenant has obligations such as paying insurance and paying property taxes to prevent the property from going into tax sale. Secondly, and presumptively, a life estate tenant is entitled to any income from the property. However, unless the words of transfer specifically allow them to encroach on capital, they are not allowed to take any of the equity out of the property. So, for example, if the property is rented out, the life estate tenant is entitled to the rents from the property. However, that tenant is not entitled to mortgage the property, taking value out of the property by a loan, reducing the equity, and basically eating away at the capital associated with the property. As I said, there's one main exception to this, and this is where the life estate transferor, the person who transfers the life estate, specifically gives the life estate tenant the right to encroach on capital. So, for example, if Abe allowed Claire, in his words of gifting, to encroach on capital, she would still have to do so in a reasonable manner, but would be allowed to encroach on capital for her needs. So moving on, let's apply this, because I think that's the hardest part of life estates, is to actually apply them to a fact scenario that you might see on a law school exam. So let's use an example and treat it like a law school exam. So I'll be putting the actual wording on a title card on the next screen, just so it's very clear, but I'll read out the words to you and then I'll put them on a title card. So in this fact scenario, Abe gives his property with the following stipulations. So he says, I grant a life estate in my house to Claire, with the remainder to Bob if Bob has children. I'm going to put this on a title card now so that you can read it, absorb it, and then I'll be back. Additional facts that are important for this application of this fact scenario are, let's assume at some point Bob does have children. And then during her life, Claire fails to put fire insurance on the property and does not maintain the roof, which leads to the property becoming moldy and flooded. And finally, Claire ends up taking a $50,000 loan against the value of the property. So in typical law school exam fashion, the question might be, what are the interests and does Bob have any claims against Claire for her actions? So the first step when answering a question like this is to set out all the interests. Think of it like a math question. You really have to show your work. And by setting out all the interests, you really set out that you're showing your work and showing that you understand the basics and the foundation upon which this question is laid. So in this case, Claire has a vested life estate interest. It's vested because there's no conditions placed on it. Now, Bob, conversely, at first has an unvested remainder interest in the property because he doesn't have children. However, once he has children, that remainder interest becomes vested. So let's assume that at the time of Claire's actions, or the actions that might give rise to a claim, Bob had kids and already had a vested interest in the lands in order to prevent any confusion. So now the question is, what are Claire's rights? So Claire is entitled to use the property for life, right? And because there's nothing further stated in the words of granting, Claire presumably has to take care of the lands. She has a right to any income derived from the lands, but she does not have a right to encroach on capital. Claire basically makes two big errors, and Bob has claims against Claire for these two reasons. The first issue, or the first thing that Claire makes a mistake on, is Claire does not properly maintain the property. She fails to keep the property insured, and fails to keep the roof maintained. Arguably, Bob would have a claim against Claire for the loss in value of the property that results, or his cost in fixing up the property because of Claire failing to do those steps. Secondly, as I said, Abe did not give Claire a right to encroach on capital in the property. Accordingly, Claire was only entitled to income from the property and was not entitled to encroach on any capital. Accordingly, she could not have taken out that $50,000 loan. As Claire encroached on that capital, Bob has a claim against her on these grounds, presumably for the $50,000 of equity that Claire took out of the property. So that is an explanation, or a basic explanation, of life estates, their application, and how to use life estates in a law school exam. I hope this was helpful. If it was, please feel free to like this video and subscribe. Take care, and I'll see you next time.